All right, our second topic, titled Setback and Access Management, WisDOT Trans 233 Experience. Our presenter is Jelinski. He's an Assistant General Counsel for the Wisconsin Department of Transportation. His legal background includes time as a litigator, handling construction defect claims, business disputes, and other real estate issues. And he's provided legal assistance on several major projects, including the St. Croix Crossing in Stillwater, Minnesota, the US 41 WIS 441 improvement project in Green Bay, and the Foxconn development, which I'm sure a couple people have heard of. So with that, I'll turn it over.
Thank you. Morning, everybody. Try to make sure I speak into the microphone here. So I'm presenting today on setback and access management, and specifically the first half of the presentation is going to be focused on WisDOT's experience with our review authority for land subdivisions, which is contained in WisDOT's Trans 233 administrative code. Just so I can get a sense of who I have in the room here, how many people are WisDOT or Wisconsin municipality people? Okay. How many people from out of state have or work for an entity or have state laws that give planners at their transportation agencies the authority to review land subdivisions? Just one. Okay. So a lot of you are WisDOT people. Again, I'm not sure how transferable this will necessarily be, the first part, to other state DOTs. But just jumping into the presentation right away, we are going to talk about, at the end, analyzing unnecessary hardships, which is the standard for granting variances to setbacks on land subdivisions once they're placed. And that standard is actually fairly universal across all 50 states. Now, there's definitely some differences between the definitional frameworks for what is an unnecessary hardship in individual states, but this concept of requiring a showing of unnecessary hardship to get a variance from a setback restriction is pretty universal. So this presentation will talk about the history of Trans 233 in Wisconsin. It's fairly controversial as of the last 20 years. What are the legal standards for granting area variances, of which granting a variance to a setback on a land subdivision is one of the area variances that we'll be talking about. Analyzing unnecessary hardships, again, which is the standard for granting a variance to this area setback, and then just practice tips on how you implement these legal requirements. So in Wisconsin, we have a statutory authorization for WisDOT to establish rules relating to establishing setbacks that manage, one, provision for the safety of entrance upon and departure from the state trunk highways, and for the preservation of the public interest and investment in the highways. And this was established initially as far back as 1949, so I think the legislature recognized early on in the history of the development of highways that land use abutting state highways was going to be an important consideration for the development of future highway projects. WisDOT eventually promulgated rules regulating land divisions with these interests in mind in the form of WIS Admin Code Chapter Trans 233. So what does Trans 233 say? Well, we'll get there because it's kind of a complicated history as of late. The current version was promulgated in 1999 and was challenged in multiple lawsuits and invalidated. So the pre-1999 version is actually what we've been using as our framework for analyzing what our authority is. And we'll take you through that, how that happened. So why would people want to challenge DOT's rule on setback enforcement and the implementation of setback restrictions on abutting land divisions? Well, because it's controversial. Anytime you have the public interest regulating what private property owners can do with their property, you're going to have conflict. Some of these considerations are the impact on development costs, having to put in, internal roadway networks, minimizing the most beneficial use of the property potentially by putting a setback in there. We can't have any improvements. Conflict, obviously, between private and public interests, conflict between state regulations and local interests, actually. And then once you put the setbacks on, disputes over granting variances to those setback restrictions that private property owners and developers may think are necessary to perform their development. So the first challenge to the newly promulgated Trans 233 occurred in 2005, and the big issue there was that the new rules allowed WisDOT not only to review subdivision plats, but all land divisions, including CSMs, condominium plats, essentially anything that required approval under Chapter 236 and was dividing property. The court concluded that the scope of 236 did not authorize DOT to regulate land divisions that weren't subdivisions within the meaning of the statutory definition, and that the regulations in Trans 233 were invalid to the extent they applied to land divisions other than subdivisions. So we lost part of it pretty quickly right off the bat. We're limited to reviewing subdivisions. So that was a fairly large blow to the rules that were promulgated in '99. The second challenge, again, people still didn't like it even after that minimization of the controls. In 2009, plaintiffs raised a number of issues, including whether these setback restrictions were a form of a regulatory taking, which is where you're essentially taking private property for use by the government without paying for it, and rulemaking procedure violations and challenges to DOT's ability to regulate the subdivisions in the form and manner that was contained in the rule. So DOT lost this case, and it actually wasn't really necessarily on the form of the regulations, but really on how the rules were promulgated, and essentially said you didn't follow the proper procedure to promulgate the rules. So the whole new set of rules that you guys put together are invalid. What was the impact of that decision? Well, as I said, the 99 and 2001 amendments to Chapter Trans 233 were declared to be invalid and unenforceable. And the effect that we believe is that, and that's contained a note in our code today, is that the order had no legal effect on the validity or enforceability of the previous version of Chapter Trans 233. And if you look at it in the code and online in the state website that has our administrative code on there, you actually have the 1999 and 2001 amendments as the code. And if you don't read that note, you wouldn't realize that you have to go down to the bottom of the code to actually figure out what the current rules are. So a lot of people just skip over that and they go right in there and say, well, you guys have all kinds of review authority. Well, no, we don't. And we haven't fixed that yet for a multitude of reasons, but that's the situation as it exists today. So some of the biggest aspects that were important for us, and getting into the discussion of variances that's coming up here, is that DOT had put in this idea of special exceptions as a broadening of the ability to grant variances to the setback restrictions. But because those were contained in the new rules, those were invalidated, and we went back to a more strict standard that was contained in the old rules. In addition, we couldn't regulate or review subdivisions other than those abutting state highways. There was some mention of ability to review land divisions on feeder roads, because obviously that generates traffic for state trunk highways. We lost that review authority too, to the extent that they didn't abut state trunk highway. So those were some big tools that we had to manage traffic and, in our view, assist developers in creating traffic patterns and traffic movements and management ideas that would be better for the public, generally speaking. But we have less of those in the current version of the code than I think we would prefer. So moving forward, what legal standards govern Trans 233 and other regulatory schemes? Well, access management and subdivision review is a form of zoning authority. Locals have that authority, the state has that authority, and we have objecting authority to that. To the extent that it's a land subdivision abutting a state trunk highway, we can object to placement of certain access points. We can require that there be a setback if there's going to be a need for future highway development in that area, where they can't place improvements. So those are some of the powers that WisDOT has with respect to land subdivisions. Area versus use zoning is an important distinction when we're talking about variances. Use zoning regulates the uses, controlling character of the neighborhood, and uniformity. That's not what we're talking about with Trans 233. We're talking about an area zoning, which regulates density, setbacks, frontage, height, dimensional attributes. And so that's an important distinction when you're talking about variances, because the standards for granting a variance for a use zoning restriction versus an area zoning restriction is different. Use restriction variances are generally more difficult to obtain, and generally will refer to this idea of no reasonable use of the property absent the variance, whereas area variances are have a little bit broader test, a multi-factor test that we apply in Wisconsin, and that many states have some variation of. So what's the point of a variance? It allows us to relieve property owners in unique and individual cases of practical difficulties or unnecessary hardships arising from the literal application of zoning ordinances. And so, again, I'm going to be talking a lot about the setback, which is where we place a setback restriction on development of structures, improvements, any sort of item of value between the highway and a certain distance back from the highway right away on the private property for purposes of maintaining areas for future highway development. And the standards for getting a variance from that have changed as the common law has changed governing that restriction. So the remainder of this presentation is going to focus on those legal considerations that we consider when granting variances. Trans 233 specifically, the version that we apply today, says that the commission, in other words, the DOT, can grant variances when the literal application of these rules and regulations will result in practical difficulty or unnecessary hardship. We also have this part about defeating an orderly overall development plan of a local unit of government. That's something we have no guidance on applying that. That's sort of something that we've been working on internally, and I don't know that has much application beyond the state of Wisconsin, so I didn't focus on that. But the highlighted part, I think, is something that will be of benefit to not only Wisconsin practitioners, but people from other states. So there's different types of variance standards, as I mentioned before. They can be formalized in the variance statute itself. Otherwise, statutes governing use and area variances will fall into three general categories. Those which allow use and non-use variances, which again, non-use, they mean area variances, and those which allow non-use variances to be granted upon a showing of practical difficulty. That's a little bit lesser standard than unnecessary hardship, and that's present in certain jurisdictions. I think North Carolina might be one that has practical difficulty as a differentiating factor for area variances versus use variances. Then there's those which allow use and non-use variances and require a showing of unnecessary hardship for both, and those which do not allow use variances and require unnecessary hardship for the granting of non-use variances, area variances. So under what category does Trans 233 fall? The second one. We allow, we don't really deal with use, but we use the unnecessary hardship for granting an area variance, so we fall under the second category. And Wisconsin falls under the second category too. So what's that standard? Let's talk about that. In Wisconsin, despite using the term practical difficulty in our code, our jurisprudence, our case law, essentially concludes that there isn't really a substantive difference between unnecessary hardship and practical difficulty. So when we're talking about granting variances, we just look at, well, have they shown an unnecessary hardship? We don't really look at whether there's a practical difficulty, as that term is used. Wisconsin's analysis for unnecessary hardship, there's 5 essential parts of it. The hardship must be based on conditions unique to the property rather than considerations personal to the property owner. And we'll talk about what all of these mean going forward. So I'll expand upon that a little bit. But that's an important one. That's a very important part of this test. The hardship cannot be self-created. You need to evaluate the hardship in light of the purpose of the zoning restriction at issue. So in the case of Trans 233, Chapter 236 talks about what purposes DOT could promulgate that rule for, managing access and preserving the public investment in the highway. So when you're applying the restrictions and evaluating variances, you've got to keep those goals in mind. You also need to look at the variance and determine whether it's contrary to the public interest. That's kind of the same thing as the third factor there. And then the property owner bears the burden of proving unnecessary hardship, which is key in the legal sense, because rather than DOT having to come in and defend their decision right off the bat, it's the property owner who essentially moves forward with their case to prove that they've met the standard for granting an unnecessary hardship, and then DOT needs to come back with the evidence to show, if they've denied it, that they had a valid reason for doing so. So let's get into the analysis of those factors. The hardship must be based on conditions unique to the property rather than considerations personal to the property owner. So I went through quite a bit of case law to kind of come up with some of the factors that have been talked about by the courts. Some of the important factors for this consideration is the lot size or shape unusual or uncommon in the area. So, if you've got a substandard parcel and everybody else in your area that's subject to the same restrictions as you has, a typical one and you're atypical, that could be a factor in whether your property is uniquely situated in a way that is an impediment for you developing it with that setback restriction on there. Is it common to other properties in the area? If you're in a downtown urban environment, you may not have a lot of land subdivisions that occur to maybe older development. So if you get a vacant area where either you've bought up a lot of dilapidated housing, or maybe a factory went out of business or something, and now you want to subdivide that land, is a setback being applied on that subdivision going to be very unusual for that nature of that use, because you're in an urban environment? All the buildings are right up to the sidewalk, but you want to keep improvements 110 feet back from your highway. That could be atypical. Minimum lot size could be a factor. Is there an issue with safety or building code requirements that's conflicting with the setback? Or did the property owner fail to plan appropriately? If they failed to plan their subdivision appropriately and then come to DOT and ask for a variance, that's probably not going to meet this first standard, because they created the problem themselves with poor planning. And we're not here, or the DOT is not necessarily here to prevent you or to relieve you from the failure to plan appropriately. Again, hardship cannot be self-created. That kind of gets to that last slide as well, but are you expanding versus establishing a permitted use? That's an important question, because if you're expanding a permitted use, for example, if you've got a restaurant and you want to put a porch on it for outdoor seating, well, if that goes into the setback variance and you come to DOT and ask us for that porch, and we've got a highway improvement that we know is going to come through and is going to be too close to that porch to allow it to be there, that doesn't necessarily prevent you from conducting your business. You've been able to conduct your business for a long time. It's just regulating the fact that you can't expand something that you've already been doing. On the other hand, if you've got an area where you're trying to establish a permitted use, the zoning is whatever it is for from the local government for that property, and you're trying to establish something that's permitted, but the setback's preventing you from doing that, that could be a factor in your favor. Flexibility of designs for permitted uses is also a question for whether it's self-created. How many buildings do you want to put on there? If it's a big condominium development, you've got a bunch of condo buildings and you want to put in there, and you're just trying to maximize how many you can put in there, well, that's not necessarily DOT's problem that you want to put in 10 condo buildings instead of 8. That doesn't prevent you from putting in condo buildings. It might affect the success of that development, but that's not something that DOT's problem, because that's a self-created hardship. There's other uses that you can do. did the previous land subdivisions create the hardship? We see this a lot in rural areas where you have maybe people subdividing land with CSMs that don't go through as strenuous of a planning process, and they fail to provide internal access for these subdivided lots as they sell them off. Well, that's a self-created hardship. The setback that DOT, might want to put on there, and again, that doesn't apply to subdivisions, to CSMs, but for purposes of example, we'll talk about it in that way. You created that issue. It wasn't DOT's setback that's creating that problem. Is it a permitted use feasible absent a variance? Again, talking about establishing versus expanding. Surveying errors, that could be a problem. Did you missurvey your subdivision plot or plat? Were there some assumptions that you made that weren't accurate? Hardship created only because the use is already constructed ongoing. That's something that we run into too. Maybe you started a construction project on a subdivision and you realize that your plan is going to encroach on that setback. Well, that might be a big problem, but that's self-created. You didn't go through the proper planning process and check your platting to figure that out. That's not necessarily a reason for DOT to grant a variance. Evaluate the request in light of the purpose of the zoning restriction. Again, I think this is essentially governed by whatever authorization you have for placing the setback restrictions. You want to look to your statute, your code, whatever it is that talks about what is the purpose of these restrictions that you're placing on the property. Trans 233 has its purpose stated right in there. You can read that. And when you're evaluating these variances, you want to keep that in mind, because if you're not granting a variance that would otherwise meet all the other items because you think that it violates this, that's something that you need to build your case up on. But if you're just not granting it because it doesn't meet some of the other things, but it also doesn't really further the goal of the setback, now you might be talking about some risk of appealing your decision on that, because you're not necessarily evaluating it fully and building up that case that this is really necessary to maintain this setback as is. And again, related to that, the variance cannot be contrary to public interest. Well, what is the public interest at stake? I think one of the biggest things is you want to look at what does your planning say. If you've got a highway that is planned, it's going through the environmental process, you're going to be building it soon, well, that's a pretty big public interest, right? We don't want a bunch of development going in that setback where we know we're putting a highway in and we have to deal with all these improvements that were placed in the setback area. On the other hand, if you've got no plans in place and it just was put on there by virtue of the fact that Trans 233 required it as part of the planning process, well, then that's not as strong of a public interest, and it's going to be difficult for you to show that granting a variance that would meet the other standards is violative of the DOT's interest in maintaining that setback. So some of these factors are important to look at, and this is really about building up the defense of denying a variance. You want to look at your planning documents. You want to establish what the burden would be on the DOT or the whatever planning agency it is. How realistic is the proposed improvement that might be coming through? Is it part of a corridors plan that's a 30-year planning document, or is it part of a 5-year plan, or is it already funded in the state budget? So you want to look at those things. So the practice tips, with all that being said, document your decision. Your denial of a variance or even your approval of a variance could potentially be looked at with a very fine-tooth comb, and you want to have a really good record of why you decided to do what you did. And that means going through all of those requirements, taking all the facts that you established in that, and explaining why you decided what you decided. So create findings of fact in a document that shows the basis of those facts. Define the standard that you're using. A lot of cases, zoning boards that denied variance requests lost because they didn't properly explain how they were applying the standard. And if you don't explain how your decision met the standard, or even that you knew what standard you were using, courts are going to say, no, you need to go back and apply the proper standard. Because if I can't tell what standard you're using, I can't tell whether you made a good decision or whether your decision was justified. So that's very important. Explain your reasoning. Why was one consideration more important than another? That's an important part of it, because a lot of times you're going to have close calls, right? And so what you want to do is say, okay, I weighed these things, and it weighed on this side because of whatever facts that you put into place. And you should explain that. You shouldn't just say, well, here were the facts, and we made this decision because it didn't meet the 5 factors. You want to say, we weighed these things, but ultimately we decided X was more important than Y because, and then explain that. Incorporate and cite any of your engineering standards or legal requirements or access management philosophies. All of that's extremely important, especially if you're dealing with, requests for variances to put in, access points or internal roads, something like that on a state highway. You want to have those standards in there. You don't want to just go through the factors and say, you didn't meet the factors, and we don't necessarily have a good safety reason for why the road can't go in here, or whatever the decision may be. You want to put those standards right in your decision. And then the better the decision is documented, the more defensible the decision is likely to be. And I think that's just true generally anytime you have something that can be appealed or challenged in front of a court or administrative body. You want to have as many facts and explain those facts and standards as well and clearly as you can. So that wraps it up for me. Any questions on what I talked about? Yes, Hans.
Do you see people just, rather than buying properties, that go with a CSM just to avoid getting the variance?
Yes. Oh, sure. Yeah, the question was, do you see people using CSMs rather than subdivision plats to avoid the potential for review by DOT to place a setback? And yes, absolutely. Absolutely. And, and it's sad from our perspective, because although I know, setback restrictions and some of these other restrictions that planning agencies will place on development can be problematic for private property holders and developers and commerce generally speaking, a lot of times we prevent people from doing things that are misguided, or maybe they don't fully appreciate what the impacts of what they're doing, especially when it's somebody who may not have a lot of experience. They have a farm and they're going to subdivide it themselves using CSMs. They don't plan for access. They don't even know that they have to get a permit from DOT to get access to the highway. We don't get to look at those things, and so that's an unfortunate result of our inability to look at the CSMs. Thanks. Mike.
Developers that use CSMs in lieu of subdivision plat, maybe to stop a setback. Statute 236, does it not say that land cannot be developed further protracted into smaller lots for 5 years, right? And so
yes.
We're seeing these developers that are doing this, and then they go back and they're even being told by certain people to go ahead and do a CSM, put your detention ponds right up against DOT's right of way, then come back and we'll get them next year. We'll go with the subdivision, and they have to approve everything existing that's not anywhere written down. That's not true. That's just something somebody started. The law is pretty clear. You can't redo that land, not even if you put it in Mike Roach LLC, change the name. I'm not 100% clear on this, but that's what I think that I've been told, is that you still can't. It's just never been tried. And so I think we're getting down to that now, where a lot of these developers are doing that. Let's just do a CSM and we'll get a subdivision next year. The whole idea is that setbacks, you don't have to buy the furniture store or the Kentucky Fried Chicken in the future.
Yeah, and Mike, I'll just summarize your question and your comment, and it kind of goes to that same thing as using the inability of DOT to review land divisions other than subdivisions and doing a piecemeal development by using a CSM to essentially get some improvements in an area that DOT is likely to object to if they have subdivision review authority. And yeah, that's a challenge for us, obviously. I mean, because we have to balance this whole conference has been talking about, we need to balance our interest in maintaining the safety of the traveling public versus the private development of property for its highest and most beneficial use. And sometimes those things are at odds. And it's not even always just private development, although that's part of it, but sometimes it's local governments that are in conflict with state DOT because, again, they have local interests, they have local development that they want to do, and the state has a little bit different subset of interests, and our interests aren't necessarily local all the time. That's a great comment. Any other questions?
All right, time for one more.
Great. Thank you, everybody.